Hi, my name is Baldev Benda, and this is my colleague Ramandeep Kaur. We are lawyers at Blackstone and Gold. Today we're going to talk about a few topics. The first would be on arbitration. So, Raman, I believe you have some questions for me. Fire away.
I do, Baldev. So let's start with arbitration. It is designed to be quicker and cheaper compared to court proceedings, but is proving to be less so over time, especially when we compare it to efficient court jurisdictions like Singapore. The SIAC has introduced new rules. Do you think they address some of these challenges?
Thank you. Okay, so the SIAC has new rules for arbitration. It is a problem. Yes, it is a problem. It's become more expensive and longer. It takes longer to do arbitration than it does litigation. And the SIAC is meant to address that, or is addressing that, by having new rules. And one of the features of their new rules would be the streamlined procedure. So as a starting point, the SIAC already has an expedited procedure, meaning the arbitration has to be done within 6 months or when the tribunal is constituted. And in that 6 months, it has to, it can decide not to do with witness evidence, no hearing, and that should truncate the process, make it quicker and cheaper. The issue with the expedited procedure is that it is an opt-in feature if certain criteria is met. For example, if the claims are below 6 million. The SIAC has now increased it to 10 million, and they've introduced a new feature called the streamlined process. And the streamlined process is quite remarkable. It is the timeline for an award under the streamlined process is 3 months. It's for claims 1 million and below, but 3 months is an exceptional amount of time. And the most important nuance people don't understand is that it applies by default. Right. So if your claim's under 1 million, you get the streamlined procedure. And with the streamlined procedure, unless the tribunal thinks otherwise, there's no hearing, there's maybe even no document production. It's meant to be a quick and fast way of getting an award, which is the whole purpose of doing arbitration.
Let's build on that. Do you have any headline suggestions for keeping time and costs low in arbitration?
Yes, it's a perennial problem and something I feel a great deal of frustration with as well on behalf of the clients. Let me give you a context of how this can be a problem, right? So let's say you've got a $10 million claim. A $10 million claim doesn't mean it's a complex claim. It could mean it's a non-payment claim, a contract claim, just a very straightforward, what we call an owe money, pay money sort of claim. Yeah. And the cost for that would be each party has to pay $200,000 to the arbitration center. What if the other party doesn't show up? Then you have to pay double, $400,000. Now imagine telling a client, you're chasing $10 million, please pay $400,000. Before you pay me, the lawyer, pay the center $400,000. It is massively unpalatable. So I think we need to think of fast-track procedures that are not limited to just the quantum. It should be, straightforward claims, I think, should have a fast-track mechanism towards that. There's a lot to be learned from how the London arbitrations do it. So the trade arbitrations, you've got GAFTA, London Maritime Arbitration, Sugar Arbitration, PHOSPHA. These arbitrations are all done in a very efficient manner. So you've got 2 rounds of submissions, you get an award, it's very quick, typically no hearing at all. And I think there's a lot to be learned about that. We can adopt some of that features. That would require a change culturally in the mindset of the arbitrator to push it forward, and also a change probably in the institutional rules. I mean, maybe the SIAC could consider putting rules catered towards non-payment claims or towards international trade claims where the matter is straightforward and the value shouldn't dictate how fast and how cheap it might be. Very sensible.
Do you see any other practical challenges, particularly with joining third parties to arbitration proceedings?
Yes, that's a problem. Has been a problem, will be a problem. I'll give you some context over here. What if you have, the nature of arbitration is bilateral. You and I enter into a contract, we've got an arbitration clause. It binds the both of us. But the world doesn't just concern just the both of us. We've got multiple complexities with commercial nuances. We've got third-party actors. And I'll give you an example of what we do in international trade, right? People buy and sell cargo all the time. So let's say there's a quality claim. I sell some oil to you, you're not happy with the quality, you bring an arbitration claim against me. But what if that quality arose because of contamination by the ship? So the ship owner had contaminated the cargo while it's being transported to you. What if after it was transported to you, it was put into a storage tank and it got contaminated there? What if the surveyor who decided what the quality is didn't do a good job? So with all these different third parties, they all have different contracts with different arbitration clauses. So it's a bit of a whole mess. We have to fight out first, and then subsequently, I have to turn back to the ship owner or to the tank operator. And that's just a long, expensive, long drawn out process, I think. So there must be ways of making it more efficient. The SIAC has tried. I think it's still, this issue is alive to it, so it's tried. And what I see with that is that you've got consolidation provisions and joinder provisions, but it's still not straightforward. I mean, you can consolidate arbitrations if it's the same arbitration agreement or similar arbitration agreement, and it's a series of, what they call a series of the same similar transactions. I think that's a term for it. The situation I just spoke about, is that the same transaction? Is that a series of similar transactions? The surveyor doing his job, is that really can that fit within the same arbitration? So I think these are complicated questions that happen in real life, and arbitration, I hope, can be a bit more dynamic to take into that account.
So in this regard, it seems that the courts are far ahead of arbitration in terms of joining third parties. Just changing gears for a bit, a most interesting update to the recent SIAC rules seems to be the introduction of a protective preliminary order, which can be sought even before a party files a notice of arbitration and on an ex parte basis. Can you tell us a bit more about that and what sort of challenges you anticipate with the use of this tool?
Sure. It's a remarkable step. I think what we call the PPO, the Prelim Protective Order, that is allows you to, for example, freeze assets on an ex parte basis, meaning you haven't given notice to the other side. And a fundamental concept of arbitration is that you need to have an opportunity to be heard. So I think there are suggestions that it might be challenged. This concept of the PPO might not be enforceable. It's because you haven't given notice to the other side. And there are a lot of naysayers, I think, on that. But I would pause for a second to say this. The emergency arbitrator concept, people have forgotten about it. It came out about 10 years ago, and the SIAC was the first one to come up with it. At that time it came out, meaning that a third-party arbitrator, who's not the guy who decides the final award, he gets to decide to freeze assets. At that time when it came out, people thought, no, you can't have that. It's not going to be enforceable. Yeah. But fast forward 10 years today, every major institution has got some form of an emergency arbitrator provision. So I would pause and take a breath here for all the naysayers. I think it will work. It's just a matter of teething issues that will happen. The protective order, I think, ultimately, if you're talking about freezing orders, I think the biggest problem with freezing orders is that it's meant to bind third parties. It's meant to prevent third parties from banks, people that hold goods on your behalf, warehouse operators, for example, from moving those goods without your say-so. And there has to be a consequence. So if I go to a tribunal today and I get a PPO, and then I go off to a warehouse operator in India, say, Mr. Operator, here's a PPO, you can't move these goods. The warehouse operator will say, who the hell are you? Why should I listen to you? And that's where I think it's going to fall apart. Right. So you still need to go back to the court, because the court gives you a penal sanction, and no one wants to breach a court order. I think there are real, criminal liability that might be attached to it. I think people are worried about that. Yeah.
Yeah. So if you still need to go back to the court, does that make the PPO somewhat superfluous?
I think there's a temptation to think so, but my answer would be no. I think the PPO gives you a safety net, a first line of recourse that you can get emergency relief quickly. And quickly is the key word over here, because think about getting court relief in Vietnam, in India, in Bangladesh. You might not get a court order for a freezing injunction in a day. So at least with the PPO, you have that safety net. Yes, there's questions of enforceability, but that's where, or whether it can bind third parties, but that's where you need to go and get a subsequent freezing injunction from a Singapore court, for example, or for that matter in that foreign court. So my answer would be the PPO is part of the package of tools available, and it should be your first line of recourse.
Would you consider that a party would be more likely to get a court freezer once it's already gotten a PPO in place?
I think there's a temptation to think so again. I think, yes, people will think, all right, a tribunal's given that, so the court should give that as well. My experiences of court, it would be that, no, I think each court will apply its own standard as to whether the test for a freezing injunction has been met, particularly that risk of dissipation element.
Since the SIAC rules now allow for a PPO to be taken out on an ex parte basis, will the Singapore courts be less likely to grant a freezing injunction because the tribunal already has the power to freeze assets?
I think this is a question to be considered. Yes, you have to understand the purpose of the court in Singapore. People say it's pro-arbitration, but it's not meant to usurp the function of the tribunal. Where the tribunal cannot act effectively, that's where the court will say, okay, I'll step in. So, for example, if you go to the court and you tell the court, the tribunal's order won't be effective to bind third parties that I need to bind to preserve the assets, the court will remember the task is to preserve the assets. And so it will lend itself towards achieving that objective.